heard in the matter 21 CV 129, Taylor Excavating LLC versus Tony DiNardo and Scott Vogel and third party Eva Development Inc. Appearances are, we do have appearing in person. We have Michael Taylor for Taylor Excavating. We have counsel Joel Porter for the Taylor Excavating. We have Ms. DiNardo as well as Mr. Vogel in person without counsel. We have Eva Development through David McGee. Mr. McGee and Mr. Porter appear by video conferencing. We're set today in this matter on a few reasons. One, a motion for reconsideration or alternate motion leave to amend. Ms. DiNardo and Mr. Vogel, you are representing yourself, is that correct?
Correct.
Yes.
And your previous counsel filed, I believe, on September 25th, a motion for reconsideration and relief, or in the alternative, motion for leave to amend. And is that what you're going to argue and stand by here today? Or why are you here and what are you asking of the court?
We are asking of the court, Your Honor, in the memorandum that you provided, stated that you would allow discussion and to, I apologize, it's right here. It says here that the court will allow the parties to present their positions on this matter. And this was filed on September 29th. And also the motion and the notice of motion and motion for sanctions.
So what I'm hearing from you, well, because yes, I now pulled up my memorandum. I probably have it in my written form in my documents right here. But in my memorandum, the court was fully directing your counsel to the errors in his brief or his inaccuracies in his brief, actually, as it related to the getting the court approval to be able to amend pleadings. And that means to add a third party defendant as well as to amend the answer and the affirmative defenses that you had in that case. Because your side, Ms. DiNardo and Mr. Vogel, you have never received the court's approval or authority to do such. And so essentially that's why we're here, or I'm going to allow you to be heard on that issue. And now I'm hearing that you would also like the court to hear again with regards to the sanctions? Or was that just a misspeak?
I think part of it, and the motion for reconsideration of your decision.
Oh,
or of the court's decision.
Of what decision?
Of, excuse me, let's see here. I do have a statement regarding the discussion from our attorney from back in April, and then motion for reconsideration regarding the court's decision to not grant further sanctions against the plaintiff.
That has already been decided because the court did its order. You asked for reconsideration. The court then had its other order, and your next step would be the Court of Appeals.
Right. And that's where, I thought there were two filings here, so my apologies. Motion for reconsideration.
Your time.
So on September 26th, he filed motion for reconsideration and relief or in the alternate, a motion for leave to amend.
Correct. And that has nothing to do with the sanctions because sanctions are done and decided and they're over.
Okay.
All right. That is a Court of Appeals matter now, if that is where you wish to go with that. But he was asking, and I pulled up his electronic document right now, it's reconsideration or relief in the correct solution under the circumstances. He was asking for the court to reconsider its decision as it related to not allowing or taking into account your amended answer and amended affirmative defenses. Okay. So that's what he was asking the court to reconsider, because in the court's order dated September 22nd, 2025, that is where the court then pointed completely squarely out to all of the parties that at no time did the court ever have any request to amend your answer, which was filed years ago, years prior to the amended answer, and to amend the answer or to add additional affirmative defenses or counterclaims. Because as my September 22nd, 2025 order states that the defendant's amended answer, affirmative defenses, and counterclaims is not received by this court and is untimely and is stricken from the record in this matter. And so the reconsideration is asking the court to reconsider that decision. And is that what you're going to argue here today?
Yes.
Okay.
Your Honor, yes.
All right. And so you can understand, I know you're lay people, you're not attorneys. Hopefully your previous counsel went over with you. Second thing is he's saying, or if the court is not going to reconsider that decision right there and is going to continue to have it struck, he was motioning the court to allow you to be heard on whether or not the court would allow you now and permit you now to amend your answer and to file more affirmative defenses and additional counterclaims.
Thank you.
So
thank you for explaining that a little bit more.
Want to make sure you understand clearly, because you're here to do the arguing. I can't assist you legally. You're here represented by yourself. I cannot assist you other than things such as explaining things so you can understand what it means legally. There may be objections here. You may have to object here too. I'm not exactly entirely sure how today's hearing is going to go. Okay?
Okay.
All right. So that's what you're going to do then, is ask the court to either reconsider or to argue to allow you to refile the second or the amended answers, etc. Okay. Now, Mr. Porter, I'm going to turn to you with regards to your position for today and the basics of what you're going to argue before we determine how we're going to proceed in the hearing.
Your Honor, I would oppose the defendant, third-party plaintiff's motion to reconsider or for leave to amend. The basis would be that there's no excusable neglect. After this, we did have the assistance of counsel throughout this matter up until now. And jumping beyond that, I do not feel the extraordinary circumstances to change your mind in the interest of the justice have been met. Again, they've had counsel all the way up until now, and there's no excuse.
All right.
The nutshell version.
Excuse me, what?
That's the nutshell version.
Yep, and that's the nutshell version. And so other than that, in your opposition to their motion, there was nothing specific that you were arguing to the court on behalf of Taylor Excavating?
Nothing other than I believe the law is that this should not be granted unless there's excusable neglect or that there's such extraordinary circumstances that the interest of justice would require it.
All right. All right. Okay. All right. Thank you. So I'm going to turn now to, first, I'm just going to have the parties here, just so we all are under oath and we're all saying things that are accurate and true and under force of contempt, or not force, but see if there are lies, etc. Can I please have all of you stand up, raise your right hands, and be sworn in?
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may be seated. So, Ms. DiNardo and Mr. Vogel, you're both here together and you are both defendants, third-party plaintiffs. You both will have an ability to argue or to say something to the court. But I need one of you at a time, okay? So don't like talk over each other and don't try and talk. If Mr. Vogel is making an argument, please refrain from trying to jump in, Ms. DiNardo. You will get your opportunity just the same. You have the ability to call witnesses. That means you can call people and you can ask them questions. You can ask each other questions, essentially, or just make your arguments and statements. You are under oath. You cannot perjure yourself, or you could be found in contempt with sanctions down the road. All right, so that's where we are. So why don't we start with you, Mr. Vogel?
Well, the reason that we're here is because, well, what I understand is that this took so long to get into place, and we did proceed with a whole bunch of other dates and everything with our other with the what do you call sanctions, not sanctions, but our attorney. I don't even know what to say. You might as well.
Well, okay.
You know, what I'm getting at is I just don't. We are at the point where we didn't have discovery from Taylor. We didn't get any of that from him, and it took how many meetings that we've had, and wondering why it wasn't being done. How come it hasn't been done? And then we left it back to you, and then it came back we came back again, and it still hasn't been done. I can't remember the dates or whatever. We got it all here, but that we're at the but then all of a sudden at the third hour, then this came in to where we didn't, obviously we're not lawyers, but we didn't know that this was something that could come back at us. But we're at the point where they didn't have discovery. They didn't for months. We gave them another chance to have discovery. Nothing came back. Talked to them again, still didn't get anything. We did sanctions, and then all of a sudden now we did something wrong at the beginning of this, way years ago.
Okay, Ms. DiNardo?
So right now there is a situation that we're dealing with the previous attorney. The only reason why we don't have Attorney Hetfield today is because of where we're at, and he set us up to be able to move forward so we didn't miss out if we needed to go to the Supreme Court.
Oh, Court of Appeals.
Or Court of Appeals, whatever, sorry, my apologies. And it was a decision that we all made together, that there's so much money that we have wasted with previous attorneys that didn't support us. And when the minute that we retained him, that's when he had actually filed for the telephone conference. And during that telephone conference, I mean, I have the description of the scheduling conference stating because Attorney Benson was on that call as well as himself. And they were very clear on what it was and the concerns, and if Attorney Benson had any objections to it, which he had none. The clerk asked how long our attorney would need, and she approved the extension, and the extension was added to the.
She can't approve it. She can't do anything. She has no authority, only I do. She's a clerk. Yep. She's not the clerk. She's my assistant. Yep. All she does is dates. That's it. All the arguments, all the things that they wanted to say, boo hoo hoo, cry, 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 none of it matters to her. She's like, whatever, doesn't matter. Okay, you want what how long do you want? The issue that falls, it's your attorney's fault. Your attorney didn't do what he needed to do and filed that in writing right away. Statute.
What I'm sorry, Your Honor, what did he need to file in writing?
You said you used to be
Yeah.
very
Where
clear
am I
with statutes. I put that statute in my decision. I'm pretty sure it must be in writing.
Okay, that makes sense.
It's very clear in the statute that any decision or any agreement and stipulation between the parties, they can agree all they want all day long, but unless it's put into writing, or I say, you know what? Okay, we're saying it in open court. You're asking this right now. Bing, bang, boom, and so be it. Either I get to say, or so be it, or it needed to be done by your attorney in writing and sent to Mr. Benson, and Mr. Benson needed to sign it with his client and get it back to, or get it filed with the court, either to your attorney or to the court. None of that happened. None of it. If they wanted to argue or cry or complain or say whatever they want to say to my assistant, it goes through the ears because she is not a part of this. She's a date person. She gets the date. That's what a status or a scheduling conference is. What dates do you need? What are you doing? Whatever negotiation they had on that between themselves, it means zip, nothing unless it's in writing. Okay?
Okay. Well, this one was a new one to me, so thank you for clarifying that. So that gives you a little bit of a history of our previous attorneys anyways. And I think that where the confusion lies then is, so if we were to go back to that February hearing though, Attorney Benson stated that him and his client have not communicated and he has not heard back from him.
I think so. I guess is she on the right track with bringing up what we're bringing up, or do we?
Well, this is your case, and you can argue it however you wish to argue it. I can't say
Right.
You're leaning more this way, or you need to push harder this way.
Is there something that
I guess if we didn't file the paperwork, right?
However, so that wasn't mentioned about the paperwork until September or October, excuse me.
Well, I'm going to tell you, he didn't want to say, oopsie doopsie doopsie.
Mm-hmm.
Look, guess what I failed to do? Okay, guess what I didn't do on your behalf that I was legally obligated to do to ensure that I covered you?
Okay.
That's what happened.
So then,
I think where you're going at is so, but I think what's important is that February 20th hearing, because at that moment you were ready to dismiss. You gave us an opportunity to dismiss the hearing in its full because Taylor hadn't provided any discovery. He's not following. Extensions were continuing. And
Well, that was his attorney's problem. Your attorney, you had 4 attorneys. None of them did anything that they needed to do for you, right? He had 1 attorney. His attorney didn't do anything that he needed to do for him, right? So you both had attorneys that weren't doing what they needed to do, to the detriment of both of you, okay? Because you both are hurting now, and you both will unfortunately be hurt, but you have the other ways to go around this. You could file with Court of Appeals. You can do that, right? But then there's that malpractice, right? Which I'm guessing that you did with one or some of the attorneys, and
that's all in the process. Yes,
yeah, sounds like that's what you're doing. And I'm going to tell you, if you have malpractice claims, though, you don't get a double windfall. You're not going to get like double from this or claim from this.
Right.
That's to cover whatever they failed to do, and they failed to protect you in this process, and what you lost in the case because of their failure to do what they should have done.
Right, and we understand that 100%. However, I know for a fact that, something like this, I mean, we're the defendants, and we were the plaintiffs in other cases, and we made sure that we stood strong. We questioned our attorneys why they didn't do this, why they're not doing that, and we didn't let it sit for 4 years. We continued to.
And again, then I say it's your fault too, because you may have had the label entitled defendants, but you had what's called counterclaims. Counterclaims means you kind of step into the footing of a plaintiff because you're saying, I am now suing you and saying you owe me for this. It's not what it is, but it's kind of like that because you're saying I have claims against you too. So you should have been just as adamant and just as on the heels of your attorney in this case, just as you were those other 3 or 4 cases where you were the plaintiff, because you had your counterclaims and you were saying, well, Taylor Excavating, they owe me, they owe us actually. We don't owe you. You owe us because of X, Y, and Z. You didn't do it right. You didn't do this and you failed to do this. Now we have to build this huge other driveway. We have to do it and it's not comporting or complying with ordinances or all those arguments that you made in your answer and then had those counterclaims. You essentially are a plaintiff, even though you're defending yourself. So you should have done all of the same things you did when you were titled plaintiff. Okay?
Yeah.
So the fact that you stepped aside or you didn't aggressively do the same actions because you thought you were a defendant, that's not an excuse.
Oh, it's not about being a defendant or plaintiff or making an excuse. I was just simply stating that back when we had the attorneys and why we just continue to question. And the reason that it took so long to find another attorney is because there were so many conflict of interests where we couldn't find an attorney. So now we're just now learning that our attorney failed us, but it's only been since it's been a short time.
Well, I want to say your latest attorney may have failed. May have, and I don't know. I don't get to make that determination. Right. That is up for the other people who are going to look at that matter. But your latest attorney may have, but it sounds like your other attorneys may have, or one or more that you believe. It's for you and for what you may feel or you may know and your claims against them. Okay, so you may continue.
I think the biggest issue here is the fact that we haven't received the discovery documents. We haven't.
You did, though. You actually did receive them.
Not until just recently. Recently. So, I mean, I think by the May 19th hearing, or the September, it was like 256 days late, or in some sense, and we still hadn't received them. And Taylor had stated that he's known about this since February, and he mentioned it while he was on the bench. At the last hearing that we had. He took the stand and stated that he has known about it since February. He's known about it all being late. He's had an opportunity.
He's been sanctioned.
$1,600. And
I don't know where you're getting $1,600.
I think I have a receipt from our attorney. That he provided.
And by the way, that my phone just rang. It's muted. It was muted. I don't know what craziness is with the silly phones, but technology. It was muted and it rang. Weird.
Whatever he was sanctioned back in February. I apologize. I keep on referencing the February hearing because at that point, there was an opportunity to dismiss it fully. And the only reason that it was not dismissed was because we were waiting for discovery responses for our counterclaim. And
again, that counterclaims that.
But at that point, nothing, no, and I get it. I understand. But at that point, it wasn't brought up or mentioned that, and so then you extended it to, you extended it by another week. Should I actually have it? Oh,
And I know the succession of the dates and times.
Yeah.
okay.
Not only have I went over it in multiple decisions and orders, but yes, I'm very clear in the timeline. So you don't have to be as clear because trust, I know those dates.
He's just like, I don't remember the date, so it's more than.
That's what so that's where my thought is at one point that this was getting to where it was going to be dismissed.
No. It was never going to be dismissed. That could have been an option, but I stated at the hearing that is a possibility. That is a severe and harsh punishment when at that time it wasn't as exactly clear if it was strictly attorney's negligence or party and attorney's negligence. But if the court would have dismissed and it would not have been the party's negligence, that is an extreme and harsh sanction.
Yeah, but it was also mentioned that in that too, that, you gave the option to our lawyer at that time, what would you like to see done here? If I'm not mistaken.
It's right here.
Can you read it?
It says.
I always ask, what are you looking for? What do you want? What are you asking of the court? I always ask that.
Okay.
It's not because I was saying, I believe everything you're saying and I'm doing all of this.
Okay.
What do you want me to do?
Right.
No, I always say, okay, just like I asked all of the parties, what would you like me to know? What are you seeking? What are you asking of the court here today?
But but at that point, that's when we held off. Why shouldn't I just dismiss this case right now?
You want me to be honest? Of saying it because of the attorney.
Yeah.
Because if it was the attorneys, I was saying it to the attorneys because, again, you all are lay people. You don't understand the sanctions and the harshness of sanctions. And when I was asking that, I believe was directed at Mr. Benson. Why shouldn't I just dismiss it right now? Why shouldn't I do that? It was directed at Mr. Benson to put him in the hot seat.
Okay.
You did state in there, because our attorney at that time, that we do have counterclaims against plaintiff as well as would be remaining. Unfortunately, we can't move forward without anything on those just due to lack of discovery. And then he said, that's where you did say, because he's like, if the court is entertaining dismissing the case, I'd also request the court would grant judgment in our favor on our counterclaims as well at that point. That's when you said that is a harsh, as you know, that is a harsh sanction for the court to provide. So I think where he's going and where both of us are going is at that point, there was an opportunity to possibly dismiss this, and I get it that you're just saying any reason why I shouldn't dismiss this, but you also stated that all deadlines must be complied with in the scheduling order, and you're going to enforce my scheduling order. And the next hearing, that's when you stated that you would like. He asked for February 28th or March.
Yep, and I gave a date.
You gave a date.
He failed to meet that.
And he failed to meet that date. And then after that date, that's when our attorney filed another motion. And that hearing on May 19th is when Taylor appeared at the hearing for the first time since.
I think he was at the February hearing.
No, I was there. He wasn't there. Just
Video.
No.
I can't recall off the top of my head, though. I know that there was one, but I did state in my decision when he did appear and when he did have full knowledge of what was going on in the case. It
Right.
could have been that March hearing.
I think when he took the stand at the last hearing, he stated that he's known about it since February. And prior to that, he's failed to make any of his discovery, and it's affected us in many different ways. And that includes, I get the counterclaim piece of it, but it just includes all of our future with, our house. We can't, if we were to sell, we can't even we have to disclose the Mogen system. And we can't, I mean, you know what, right or wrong, that part doesn't even matter. There's just so many areas that we are being left with because he didn't provide us with the discovery and interrogatory statements. He's 100% violated all of the statutes to help us get to our next steps. We've done everything that's been asked of us.
Well, they're now.
Okay, well, that's where we need to
And again, you guys
address
can't
the
talk back
attorney.
and forth.
Oh, yeah. So that's that. Facts are facts. He just did not provide any of the discovery, and he had an opportunity to provide you with a letter, a written statement that states.
Not Mr. Taylor.
Yes.
Nope, not Mr. Taylor. That was directed to his attorney. Why his attorney did not do it. That was not directed at Mr. Taylor.
Because
Did the attorney?
What's it? Oh, we can't talk. Ask.
Did the attorney give his explanation?
Well, if it's not in your file, then you don't have it. But here's the thing, he did not. And that's exactly then why it's went the route it has. And at that point in time, it became clear that Mr. Taylor was not fully aware of all that was going on in his case, just like you two were not fully aware of all that was going on and not going on in your case. You both have had things going on and not going on that should have been going on that neither of you, all three of you, were not aware of. That became very apparent to this court, very apparent to this court.
I guess the only other piece, I just feel like, we are responsible for, we've got a letter of engagement that we have with our attorneys, and it's up to us to enforce them, and we have enforced them, and which is why we've got claims with Office of Lawyer Regulation, Wisconsin Lawyer Fund. We've got mediation set, we are, and with all of them, not just one.
No, and I understand that, and I get, I'm gonna let you know, let you all know, I get the predicament that all three of you are in, all three of you, 1, 2, 3. There have been multiple errors done by both sides. Neither side, and that's why I was so harsh in my memorandum to your last attorney. He tried to tell the court that the court didn't know what the court had said and what the court had done, and that the court does not understand the law. I do. I very clearly do. I understand my cases very well.
Yeah.
And so I wanted to ensure that he knew. And that's why it was like, boom, I shot it off right away. I know my cases. I know them. I know my dates. I know my facts. But the thing is like this case has had nothing go on for, I think, 3 years, neither side. And then both sides asked the court, hey, can we have more time? Because we didn't listen to you the first time. We didn't follow your direction the first time. I'm going to tell you, I could have dismissed this case outright so many times for both sides. And I did not, because I thought, okay, let's get this going. But now we're going on 4 years and nothing has happened. So, all right. So, Mr. Porter, your arguments?
Yes, Your Honor. And if this had been a question and answer format by counsel, I would have been objecting throughout it. But I'll just make one objection now. Everything they've said relates to sanctions about not getting discovery and so on. And that's not why we're here today. We're here for their motion for leave to amend, or leave for permission to file an amended answer and counterclaim. Also then, because their counsel did not comply with your court's original scheduling order, that amended answer and counterclaim were years late. As an aside then, all that discovery related to the amended answer and counterclaim, which your court has stricken. So I don't see that there's any reason for any renewed sanctions if that's what they're now requesting.
I don't believe they are. I think they misunderstood all the steps were and where we were. That's my understanding.
Okay. But the bottom line is that their counsel, whichever one of the counsel did not file that in a timely manner and did not request leave to file it. Again, from their testimony, there's been no excusable neglect. It's very seldom that the court grants excusable neglect for the errors of counsel.
And I'm just going to stop you right now, just because they're not represented, and I'm just going to point to them because you have a pen and paper. There are some key words you probably should be taking down of what he's saying and what he's arguing. I'm not going to tell you what they mean or anything like that. I'm just pointing out he's making a good argument about the law and what the law is and what the court has to look at. So key words like that you might want to jot down and look at after. Okay? All right, Mr. Porter, sorry.
Yes, and for the defendant, third-party plaintiff's benefit, I think some of those keywords are excusable neglect and interest of justice. And if they Google those, they'll find them in the statutes and they can do their own research beyond that. But it's my position that nothing they have said shows excusable neglect. Nothing they have said shows that there are extraordinary circumstances here such that the judge should give them leave to do those things in the interest of justice. And Your Honor, it's too smart for me to sit here and bore you with more, and I don't think any additional testimony is necessary. I think everything's in the record.
All right, thank you. I appreciate that. Mr. Porter did state exactly what case law does state for the court, and perhaps it is identified in the statutes as well. And that's why I just wanted to make sure that you understood what he was arguing and saying. Key words that pop out to me, interest of justice, is something that the court has to look at. I'm going to tell you, as of right now, in the interest of justice for both sides, quite honestly, in the interest of justice for both sides, I've heard both sides and their arguments, and I have a really good understanding of this case and what happened, what didn't happen, what should have happened, and what didn't happen, etc. In the interest of justice, I'm staying on a decision as it relates to these matters because I'm ordering mediation one more time. Okay? So I'm going to order mediation one more time. If I were, and you wanted me to make a decision here today on the bench, or even if you wanted me to do a written one, I do it far more thoroughly. But if you want me to make a decision here on the bench, I don't think either side will be happy. Either side will feel like justice was served. Both sides will probably feel forlorn. So I am staying on my decision as it relates to this matter, and I'm going to order mediation.
Going into mediation, and once again, part of the issue when we went into mediation previously, the attorneys were not, Attorney Benson was not given the information from our previous attorney of everything that we had learned.
Well, here's the deal. You all know where we are right here today. You know that you may not have any counterclaims. You may not have any additional affirmative defenses. You may be where you are at the very beginning. And you know, and Mr. Taylor and Mr. Porter knows where Mr. Taylor sits from the sanctions. So you both know that you're not at the best of all best places that you both could be. And Mr. McGee, the parties know where EVA Developments sit, and you sit from that decision, because in that decision, I was very clear at what could still remain outside of with your arguments or your claims against EVA Development. EVA Development, we went through a very thorough summary judgment hearing with EVA Development. Therefore, the court is not striking the third-party complaint. That is remaining,
Okay,
okay?
okay,
Because that should have been something raised by Eva Development at the time and said, hey, judge, this is where we are. That's why we shouldn't even be here. That would have been wham, bam, done. But it went to a full hearing. It went to a full decision. So that they waived the right for that defense. Okay?
okay,
All right. So, but that it's very clear. So read my decisions and you'll see, because in my decision, as it relates to the driveway anyway, your arguments where it doesn't, it's not compliant with Burnett County ordinance, blah, 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 but it is, because I have that documentation and that evidence from the county. Okay. So read and you'll see where Eva stands. You'll see where you stand in those arguments. And then where you could possibly stand at here or here, depending. And you have my last decision, so you have an idea of what could happen, just as Taylor Excavating and Mr. Porter do. Okay?
okay,
So I'm ordering all sides to be very open and trying to be willing to work in mediation. Okay?
okay.
All right. So can we do January 14th?
My wife of 53 years and I are going to be in Mexico, Your Honor.
Well, I don't.
And if my cell phone works, I could do it that way.
Nope. I'm not. I don't interrupt vacations. That's one thing I don't do. Unless this was a homicide case or something.